Good afternoon, everyone. My name is Kavita Jan, and I'm your coordinator for today. Hope you all are safe and healthy. Today we have with us Mr. Madhusudan Jaina, Deputy General Manager and Head Legal, MMTC Limited. MMTC is a public sector undertaking, I hope you all know. Mr. Jaina has done Master in Law from Andhra University, Visakhapatnam. He is also postgraduate in Public Administration from Utkal University, Bhubaneswar. Mr. Jaina has 24 years of rich experience in litigation management and structuring, weighting, reviewing various kinds of domestic and international contracts. He is managing a team of 16 in-house lawyers and approximately 50 external advocates in his current employment. If you look at his professional career, Mr. Jaina has many accomplishments in his bucket. He has been instrumental in dismissal of a claim to the tune of 1,400 crores during 2020 by the Divisional Bench of Delhi High Court at the stage of an appeal under Section 37 of Arbitration and Conciliation Act 1997. He has also been instrumental in disallowing a claim of a reputed public sector undertaking to the tune of 100 crores at the arbitration stage during the year 2012. He played a critical role in questioning a demand of rupees 195 crore of Commercial Tax Department of Odisha. The list of his achievements is endless. Considering the available time we all have, I would rather prefer that all of us take the maximum benefit of Mr. Jaina's presence today. So without wasting much time, please help me welcome Mr. Jaina to share his knowledge and experience on the topic bids and related aspects. Thank you, Mr. Jaina, and welcome you, and over to you. Mr. Jaina, please unmute yourself.
Yes, thanks, Kavita ji. I am audible, ma'am?
Yes, you are audible.
Yes. Thanks a lot for giving me the privilege to address the candidates. So, thanks to the team of ICSI. Good afternoon, friends. As Kavita ji said, myself Madhusudan Jaina and now head legal of MMTC. And today's topic is bidding process and related law. So what is my suggestions? The time has allowed 1.5 hours for the presentation, and thereafter we will look into the interactive session, questionnaire session. So in the meanwhile, if you have any queries, we will be taking up after the session is completed, my presentation is completed. So please bear with me in this regard, friends. So broadly, I am coming to the topic. As you are aware, for why tendering process is followed, because it is quantitative, qualitative goods in a competitive price. That is the main issue of a tendering process. So before the tendering process is followed, the request. Hello. Request for information and request for proposal and request for quotation. There are basic things prior to the tendering process is followed. So first of all, we'll touch upon this RFI, RFP and RFQ. Okay, friends? Are you in the PPT? Hi.
Yes, sir, please go ahead.
Okay. Though the RFI, RFP and RFQ are look to be similar, but they are different definitions and have served different purposes within the procurement process. Therefore, it is independent to each other. Sometimes you will need to start with a request for information to better understand your market, and then with that knowledge, you may move to issue a RFQ or RFP. Okay, friends? So now we will go to the details of the RFI. It is a formal process for gathering information from potential suppliers of goods or services, and it is intended to be written by the customer and sent to potential suppliers. An RFI is typically the first and most broad series of requests intended to narrow down a list of potential vendors. So broadly speaking, it is the first process of the tendering process. That means when you are not aware of anything, who is the vendor, what is the quality, what is the price, so then you have to follow the first process of RFI. So broadly, it is mostly in the software industry, the software, hardware integration. There are so many things we are not aware of it. So that is why it is broadly followed in the IT industry, followed by construction, ad agencies, and health industry. But in the normal setup, like quotations and the tendering process, we will follow. So in the IT industry, the software will typically be used for a long period of time. So it is important that an organization is able to select from the right vendor, because your location, somebody may be in New York, somebody in Bangalore, and they used to integrate, and they used to know the exact who is the vendor, what is the quality, and what is the reputation of the vendor. All these things is to be taken into consideration. That is why there is a need to request with RFI, the first mode is required to be followed. The next one is in construction industry. There is so many stakeholders are involved. That means the principal, the main contractor, the subcontractor, the designer, to some other clients. There is a integration is required in relating to so many stakeholders. So I am coming to just like a power plant project. Suppose you have to erect a power plant, but you have L&T, suppose is a contractor. The main contractor is L&T, but in the process you will engage a series of people like from construction, civil contractor, mechanical erections, electrical issues, and so many other aspects like integration is badly required. So that is why this RFI mode is badly required to collect the information from all the stakeholders and integrate it, and accordingly you can proceed to the next process.
So just people are saying that the audio is not so clear. So could you come near to the mic?
Yes, ma'am. Actually, I have this earphone. This is okay, I think, ma'am. I will make it a louder voice.
Yeah, I am getting, but some of the participants have messaged that they are not able to hear you.
In fact, there may be from my side it is okay, ma'am. So there may be some network problem from their side. Again, I will reassure you. I will make a little bit louder voice.
Okay.
Now it is okay, ma'am.
Yes, sir, please.
Okay, ma'am. So next is RFP. It is request for proposal. Normally, it is from the potential vendors. So you have a database that I have the potential vendors for a particular item, whether it is service or goods or it is a project. So accordingly, you have to go for the RFP. It is mainly to help in the criteria. And it is more specific. There are two parts. One is the evaluation, and it is more specific. But all these things are internal mechanisms to assess your bidding process, how to go about the bidding process. The next one is RFQ. This is the quotation, request for quotation. This is mainly when it is small items and you are not sure of the pricing. So exactly the price purpose and quantifiable such as hardware items or any other small items, you can go for a direct quotation. You are acquainted with the quotation process. So I don't need to highlight on this part. We will go to the major part, what is the tendering process, what is the legal issues involved, what is the role of bank guarantee, and when a bank guarantee will go, we will also address. The bottom line for this RFI, RFQ, and RFP, if you are procuring for a specific service and know exactly what you want, then RFQ is the best option. And if you are in only very raw stage, then you need RFI. And if you are in little bit advanced stage, you can go for a RFP. This is the bottom line and broadly the difference between RFI, RFQ, and RFP. Okay, friends? And next process is how to respond to RFQ. This is understanding all RFP requirements, assign due dates and tasks, respond to RFP questions, review and revise RFP responses, finalize and approve RFP, submit RFP to user. These are all non-legal issues. It is purely in the process of evaluating and responding and preparation for going for a bidding process. This is the main issue. We are coming to the how this standard bid document is prepared. This is a major issue. Instruction to the bidder. What is the instruction you want to pass on? So it has to be very, very carefully drafted, designed, and the tender notice to be prepared. Conditions of contract. So what is the time schedule and what is the role and responsibility? What is the scope of the contract? All these things should be taken into one document, that is the condition of the contract. And what is the penalty clause? What is the risk is passed on? What is the tax implication? So all these factors should be taken in the condition of the contract. Schedule of requirements. So normally in the mega project, there is a series of transactions effected. So you have to invariably mention the schedule of requirements. After 1 month, this is required. After 2 months, this is required because it is integrated. So once you have that particular item, the next process will start. So there should not be any break in the chain. That is why the schedule of requirement is required to be very clearly mentioned in the tender paper. Specifications and allied technical details. What is the particular brand of the item, size of the item, and the connected technical issues has to also be mentioned in the specification process. Price schedule. So particular item, what is the price, what is the tax, so all these things also to be mentioned. So because you are not dealing with a small particular item, when you are dealing with the mega project, with road project, power plant project, or any bridge construction. So there is a series of issues involved and which are interconnected to each other. So that is why the specification, the price schedule has to be very, very carefully designed and mentioned in the tender paper. Then the contract form. As you know, there is section 10 of the Contract Act deals with the valid contract. So all these features should be defined. Like, yes, ma'am.
Sir, participants are continuously saying that their sound is breaking. So
yes, ma'am. So my sound, you are audible, ma'am?
Yeah, when you speak like this, it's better. It's quite clear.
Yes, yes. That means I have to be little bit more louder.
Yeah.
Yes, ma'am. Yes.
Thank you so much.
Yes, ma'am. Sorry for the inconvenience. Yes, ma'am. So in a contract form, the basic structuring contract points has to be taken into consideration, like the first preamble, then the specifications, then the technical specifications, then the pricing mechanism, the payment mode, and then the passing of the risk, tax implications, and then the force majeure clause, dispute resolution mechanism, jurisdiction clause. All these things has to be there part of the tender process. So, because the party who is giving a bid, he should be aware, if I am getting this work order, then what will be my role and responsibility and what is the risk factor I have to take in. Therefore, it has to be very, very carefully, clearly designed, structured, and it should be part of the tendering process. Then other standard forms like performance guarantee form or any other certification is to be required to be given, that has to be taken into consideration while structuring the other standard forms. This is the process, how the tendering process starts, starting from the very beginning. First of all, you have to design the estimate. What exactly your estimate and quantity wise and money wise. Suppose you have a project worth of 100 crores and you have a time span of 6 months. Because if you are running time, then the cost factor will increase. So this part has to be taken into mind. Accordingly, it has to be estimated. The next one is expression of interest. So what we have discussed, like RFP, RFQ, that is the pre-bidding process, and you have collected some information. Accordingly, you have to design your expression of interest. The next is the pre-bidding process, conference. Before going for the NIT, normally in the major industries or big projects, they go for a pre-bid conference. That what we exactly need and what we exactly require from the vendor. And there is suggestions from either side, and accordingly the NIT is designed. Okay, friends? So next one is, once you have decided the specifications, technical estimate and other factors, then the NIT you have to load in the website. And sometimes there is a small notification, the detail is available in the company's website or organization's website. So here is one part to be remembered, that the earnest money deposit or EMD is one of the integral part of the NIT process. So, because if there is no EMD, one thing you are in the process of a risk. Secondly, the person, those who are not also interested in the work, they may come forward. So to restrict the number of vendors as well as to safeguard the interest of the principal, EMD requirement is there. So that is normally 1 to 2% of the tender. Next process is bidding. Next is the technical team. Then once the bidding is over, then tender opening committee. There are two aspects. One is technical specification, the other one is financial specification. So the first round and second round, once the person is qualified in the first round, then only he will be considered for the second round. Otherwise, in the first round, suppose there are 100 vendors, offers are there, and 50 has been rejected in the technical round. Only the 50 has to be considered for the second round, that is the financial bid. So here, before going further, I just wanted to highlight one aspect, that the tender is nothing but an invitation to offer. It is not an offer itself. So therefore, it should be very clearly understood that the NIT launched or notified by a principal is a invitation to offer. So in response to the invitation to offer, the offer that is in form of the bid has to be submitted. So once the bid is accepted, then it is the offer, acceptance of the offer is communicated. So then a contract came into force, subject to the conditions of the purchase order or letter of acceptance or letter of intent. Okay. Now we come to the tender evaluation committee. So now once the technical bid is completed, the second phase is the financial bid. So once the financial bid is over, now tender evaluation committee, which is normally by the marketing or trading division, the finance division, and the legal department is to be there. And the evaluation process has to be mentioned in the tender document itself. And what is the process of evaluating each bid? Then the next process is the approval. That is the internal mechanism. So after the delegation of powers of each company, they have suppose up to 5 crores, which is general manager, up to 10 crores, which is the director, or up to 50 crores, that is the board of directors of the company. That depends upon each organization setup. But invariably, as per the CBC guideline, it has to be approved by the competent authority. Unless until it is approved, you cannot communicate. So sometimes before going for a long-term contract or a full-fledged contract, there is a condition mentioned in the purchase order or in the letter of acceptance that this issue is subject to approval of the competent authority. So in that situation, it is not a considered contract by itself, because there is a condition attached to the condition attached to the acceptance. So there is a case relating to this exact issue, because if that the condition is not fulfilled, then this is not a contract by itself. That is the case is in Shankar Bhatt, which is reported in 2003-4 Supreme Court cases, page number 86. This signifies that if there is a letter of acceptance has been given, which is required to be ratified by the competent authority, and if the same is not ratified, then it is not a concluded contract. So broadly speaking, it is a condition, and if the condition is not fulfilled, the contract is not valid. So you may read with section 7 of the contract law, which is unconditional acceptance. It says it is unconditional acceptance of the offer. So for reference purpose, I can have a look to the section 7 of the contract law. In order to convert a proposal into a promise, the acceptance must be absolute and unqualified, be expressed in some usual and reasonable manner, unless the proposal prescribes the manner in which it is to be accepted. If the proposal prescribes a manner in which it is to be accepted, and the acceptance is not made in such manner, the proposer may, within a reasonable time after the acceptance is communicated to him, insist that his proposal shall be accepted in a prescribed manner, and not otherwise. But if he fails to do so, he has to accept it. Yes,
so I'm sorry to disturb you, but maybe little more if you can come near to the mic.
Yes, ma'am.
Participants are continuously sharing that they are not able to hear you clearly. So kindly just...
Yes, ma'am. Now I am very close and I have this speaker also. Now it is audible?
No, I think it is better. I think it's much better. So
yes, that means
in this position.
Yes.
Yeah. Thank you.
Yes, ma'am. I have to be more louder.
Yeah. Okay.
Yes. So what I am talking, that is, there is a condition attached to the acceptance. So there is a condition attached to the acceptance, and the acceptance must be absolute and unqualified, be expressed in some usual and reasonable manner, unless the proposal prescribes the manner in which it is to be accepted. If the proposal prescribes a manner in which it is to be accepted, then it is not a concluded contract. The section 7 of the contract law is to be qualified. That means there should be unconditional acceptance of the offer. Then only a concluded contract came into force. And if there is a designed form in the tender notice, in that form only it has to be communicated. Otherwise, that is not a valid communication. Okay, friends? We will move to the next point here. So now the purchase order, normally there is so many concepts for to immediately start the work, purchase order is issued. Sometimes the purchase order itself is a contract. Sometimes it follows with a full-fledged contract. So now the question arose, if the purchase order is containing all the major ingredients like quality, quantity, price, and other factors, then it is a contract by itself. But the parties sometimes intend to have a full-fledged contract with detailed terms and conditions, which is required to be issued in a later stage. If there is any condition mentioned therein in the purchase order, then the purchase order is itself not a contract, unless until the condition is fulfilled. Okay? Right? Next one is award of a contract. So that is the next process what I discussed today. Once the purchase order is issued, the next process is whether we will go for full-fledged contract and awarding the work. So in this present situation, then arose the security deposit. Security deposit sometimes it refers to performance guarantee. If it is in cash, then it is known as security deposit. But security deposit and performance guarantee are two different things. Security deposit will come on end when the execution is over, whereas performance guarantee has a extended period, suppose for 6 months, that is defect extension period. So security deposit is the first phase, which is followed by the performance guarantee. Sometimes instead of taking the security deposit, performance guarantee is directly taken once the award is of contract is issued. Then by that point of time, the refund of EMD will come into the picture, because the unsuccessful bidders are required to be refunded with the EMD amount. Suppose out of 100 bidders, you have to give work to one bidder, to 99. Hello? Hello?
Yes, sir.
Sorry, ma'am. There was a call I disconnected. Sorry, ma'am.
No.
Sorry.
But sir, just the same request, kindly be near to the mic. Things will be sorted. I don't know if your internet connection is appropriate, because
Yes, my connection is okay, ma'am. My connection is okay.
Okay. So maybe little more louder if you please.
I think there is some. Hello. Is it better, ma'am? And there is some volume increase.
Yes, it is much better now.
It is okay, ma'am?
Yes, please.
There is some volume was less. Okay, ma'am.
Okay.
Now the question is of refund of EMD. The unsuccessful bidders are required to be refunded with the EMD amount, because there should not be delay. Normally there is an interest is payable on the EMD amount, so that is why as soon as possible, so it has to be refunded to them. Then the last stage of the tendering process is you have to load it in the website that such and such person has been awarded with the work, and this is the duration of the work. Because it is in the public domain, everybody should have access to it. Next one is evaluation, the minute evaluation of the process. Once the tender is issued, then tender document must clearly specify evaluation criteria. So it is the in-house process that what is your evaluation criteria, you have to mention in the tender document itself. So like, for example, two types of bid, that is technical bid and financial bid. Tender evaluation is in accordance with the criteria evaluation. So accordingly, you cannot go beyond what you have mentioned in the tender evaluation process. You have to stick to the process only. Otherwise, it will be arbitrary and will be subject to the scrutiny of the court. This is the next process of the evaluation. Time taken for evaluation and extension of tender validity. Suppose you have some technical issues relating to the evaluation and you need more time. Then you have to extend the tender validity period. Next one is process of tender evaluation to be confidential until the award of the work is notified. It is purely confidentiality to be maintained because no information to be passed on either by the internal mechanism or through the external mechanism or through the vendors. So strictly confidentiality to be maintained. So now the issue is, what is the difference between the tender opening committee and the tender evaluation committee? This is also tender opening committee has simply they have a role. What are the tenders are there, whether the financial bid and the technical bid is completed, their role is to that extent. But the tender evaluation committee are the experts in the field, those who are evaluate the process of the work, the competence of the contractor, the reputation, and all these things is to be taken into the consideration. And this is the basic, whether the tenderer meets the eligibility criteria, whether the crucial documents have been submitted and duly signed and attested, whether the requisite EMD has been furnished. So these are the things which must be initially examined before the technical bid is to be taken into consideration or at the time of the technical bid is to be examined, verified. Which is the next process, satisfaction of conditions specific to the contract, sample testing, capacity evaluation, turnover of this company. Suppose you have the contractor should have a turnover of 100 crores for the last previous year. If there is a deficit, then it is to be rejected. Then next is the statutory documentation like income tax certificates and the sales tax clearance and other registrations like labor registrations or other any other issues or competent authority declarations that has statutory coming under the purview of statutory documentation. This document is required to be verified. Arrival at the outcome price of the bid. So this is the bid pricing, whether exactly as per the requirement, the price is reasonable or it is in a very lower side or it is not feasible. So these are the issues to be examined at length. So it should be justifiable, reasonable. Then only you can go for the next process. Alright. Then determination of L1, L2, and L3. Keeping in view all the factors we have discussed, the L1, L2, and L3, because you have to see. Suppose in the case of L1, the prices are low, but his reputation is not good, or you are feeling that he may not complete it within the specific time frame. Then there is a scope for go to the L2. Though there is certain embargo restrictions imposed by the CBC guidelines, but still you have to maintain a channel, and if necessary at the time of negotiation, you can match the L1 to L2 to L1 and give the order. But so many factors is required to be taken into consideration at the time of determining L1, L2, and L3. determining reasonableness of the L1 rate. So what I have discussed here, the L1 rate is whether it is reasonable, justified, appropriate, or it is imaginary nature. You have to examine it. Suppose if it is imaginary nature, you cannot complete the work in time, and the quality you will compromise with the quality. So this factor is required to be taken into consideration at this stage. Next one is the recommendation for negotiation. So you have to recommend, suppose you have reached at this point and you need negotiation. You are not happy with L1 as because it is reasonableness is not okay, or it is the prices are not up to your expectation and it is quite low, and it may not be feasible to continue with the qualitative work. In that situation, you can come for negotiation of the bidder and the after negotiating exactly after your satisfaction, you can give it to the either L1 or L2. But here the question arose, whether can you give to L2? There is a lot of hindrance and embargo. Yes, you can give to L2, but you have to justify why he is not fit or why you are not issuing to L1. If it is justifiable, recorded, then the court intervention is minimized. If your decision is arbitrary, nullified, then in that case, court will cancel the entire process and may direct to give to L1. Okay, friends, we can move to the next one. These are the CBC guidelines in pre-award stage. This is applicable to government organizations. So far as the private organizations are concerned, they have their own setup. But for broadly, for understanding and government guidelines is to be followed for the government setup. So I have prepared this slide. So let us have a look to it. Financial and technical sanction of competent authority is available. That means in a government setup, the delegation of power is invariably to be followed. Because if there is any violation of the delegation of power, then it is coming under the category of misconduct, and one person is liable for penalty and punishment. Therefore, these things need to be taken into consideration whether there is approval of the specific authority or not. Second one is adequate publicity given or not, because otherwise it may lead to catalyzation or favoritism. So that is why the adequate publicity is a mandate given by the CBC guidelines. So you have to invariably follow this process. Advertisement is posted in the website. Now, earlier days it was open tender and box system. Nowadays it is everything online system. So this is wide publicity to be given in the website as well as it has to be uploaded in the website. And documents are available for downloading because it should be user friendly. That means the documents are downloadable. If there is any issue, then it may lead to the arbitrariness or favoritism or unreasonableness. So there is every scope in every stage that it should be to the putting of the judicial process. So we should be very careful that the website is properly working and it is downloadable and everybody has access to it. Next one is convenient tender receiving opening time and address of the tender receiving official tender must are properly notified. These things have to be invariably mentioned in the tender paper that this is the closing time and suppose 5:30, 31st October 5:30. So this is the closing time. In case there is after 5 minutes anybody is coming or requesting, then it will not be considered. That you have to strictly follow the timeline. The next one is suppose it is 1st November 10:30, you have to open the tender. and in presence of the bidder. It has to be mentioned therein. So there should not be any variation in the timing or venue of the opening process. The next one is in the case of limited tender, channel is referred in a transparent manner, clearly publishing the eligibility criteria. So this is related to when there is a time factor is very lengthy and you want to go for a immediate execution of the work. So limited tender you can follow within the network of the vendor data available. It is not open. So that is why limit, but the condition is transparent should be maintained. The next one is pre-qualification criteria are properly defined or notified. Suppose you have not mentioned particular criteria and you are in your mind that this is to be taken into consideration while scrutinizing or examining, then that is a law you are committing if it is not mentioned. So whatever is mentioned, whatever is stated there in the tender, accordingly you have to proceed. There should not be any variation or going beyond the scope of the tender norms. Okay, friends? Next one. Here it is the very biggest issue, EMD. Normally it is up to the 5% of the estimated value. Suppose you have a 1 lakh turnover or transaction, then you may go up to maximum 5,000. It depends upon item case-to-case basis. It has to be decided by the principal that how what will be the 2%, 3% or 5%, but it should not be normally more than 5%. And what is the mode of the EMD? Whether it is a DD, FDR, banker check or GD. So it has to be decided. Suppose anybody is going beyond this mode of a deposit, then it is a non-fulfillment of the conditions of the tender. So in that situation, in absence of the proper EMD as mentioned in the tender document, the same will be rejected. Therefore, it is applicable to both to the bidder as well as to the tenderer that we have to go in very carefully and accordingly act. Unsuccessful bidders EMD should be returned as soon as the process is over. This is performance security, the next one. It is normally from the successful bidder and amounts to 5 to 10%. DD, ADR or bank guarantee at the case may be. And normally it should be valid minimum for a period of 60 days to maximum period of 6 months. Because in mega projects, the defect liability period is normally 6 months to 1 year. So till such time that is that the defect is not rectified, you can hold the performance security. In case of any difficulties or any discrepancies, then you can adjust the performance guarantee. So, a reasonable amount to be given 5 to 10%. And insofar as the security, bid security is concerned, that is required to be refunded. There is a lot of legal issue relating to the EMD and performance security, because in the process of the work, these are the issues arose. These guarantee are issued for the performance of a contract or an obligation if the contractor or the supplier does not complete the project on time or not supply the goods as per the specification and does not compensate the principal for the loss. The principal can claim the loss from the bank with the bank guarantee. Normally, we are talking about the performance guarantee in the bank guarantee mode. The bank is giving a guarantee not for the performance, but for the, if any, because normally it is unconditional guarantee is taken normally. So the bank are usually not giving guarantee for the performance, but merely guarantee that if the customer fails to perform, it will be liable to pay the guarantee. So here the final line is, bank never gives guarantee performance. Bank gives guarantee on behalf of the customer. If the customer fails, it will be liable to pay the guarantee amount unconditionally. Here, the major point is, though the performance guarantee emanates from the original contract between the principal and the lender, it is a separate contract by itself, because the guarantee normally is given by the bank on behalf of the lender to the principal, and it is unconditional. There is a lot of issues relating to invocation of bank guarantee. I will come in the subsequent slides and I will explain to you. This is invocation of bank guarantee because the parties should be ensured if there is any defect and the defect is not rectified, or there is some damage to the goods or in the services, then we should be in a position to invoke the bank guarantee. It should be a safer side. So the beneficiary need to invoke the bank guarantee on or before the expiry date of the guarantee. Normally, the guarantee period after the execution of the work, there is 60 days to 6 months, it has been mentioned, depending upon the case-to-case basis. The bank does not receive any claim on or before the validity period. Suppose in a particular incident, 31st December 2020 is the validity period of the invocation of the guarantee. And you came up in the month of January 2020 saying that I have invoked the bank guarantee. So this is not permissible under the law. Whatever you have to do within the time frame as mentioned in the guarantee. And the bank obligation under the guarantee has already been discharged on the date of which is validity, that is 31st December 2020. The next one is the bank guarantee, the unconditional guarantee, and undertakes to pay without demur, which makes the demand conclusive and binding. It is, though it is emanated from the original contract, but it is an independent contract by itself. Suppose whether there is performance, non-performance, we cannot, with the guise of the party or initiation of the party, the bank cannot deny the invocation of the bank guarantee. So that is why unconditional bank guarantee is taken. However, in the normal practice, banks need to inform the lender that the guarantee is likely to be encashed. So normally the lender needs to go for an application for injection before you invoke the guarantee and realize the money. So this is a normal practice, everybody is aware of it. But so far as the law is concerned, banks cannot deny the invocation of the guarantee under any ground. There are two exceptions to the invocation of the bank guarantee. The first one is if it is egregious in nature and vitiate the entire under fraud. If there is fraud and the established fraud, there is established fraud and fraud means, suppose here there is a ground that he has committed a fraud. But it should be established by simply stating that a fraud has been let out to him. The bank cannot be escape from its liability. Therefore, there is fraud and vitiate the entire underlying transaction of which the bank has a notice in that situation. And it is a very, very difficult situation to decide whether there is a fraud or not. Only the court of law can decide whether there is a valid fraud or not. The next point is special equity in form of preventing irreparable injustice. Whether there is irreparable injustice met out, only in these two conditions the bank guarantee can be denied to be invoked. But it is the rarest of the rare cases. In 99% cases, the bank has to invoke the guarantee or encourage the guarantee. So this is what is fraud under the contract law section 17 says that in a case referred by Supreme Court in Reliance Salt and Personal Enterprises, the commission of fraud would include any act committed by a party to deceive another party or his agent or to induce him to enter into a contract. And the burden of proving such fraud lies upon the party making such allegation. That means the person who is making that there is a fraud has been committed, the onus is lying with him to prove, not with the party who is defending. And fraud, influencing, or it is a direct fraud, this is as per section 17, read with the decision, so many decisions. I have quoted only one decision of the Supreme Court. But it is a very rarest of the rare occasion where the bank guarantee can be denied. The next one is, second exception, is if there is irreparable harm or injustice to one of the parties concerned, the harm or injustice contemplated under this head must be of such an exceptional and irreparable nature that it will override the terms of the guarantee and the adverse effect of such an injection on commercial dealing in the country is severe. Because there are two parts. One is the irreparable injustice met out, the other one is fraud. But these are the very, very exceptional situations and it has to be seen on a case-to-case basis. Under the guise of these exceptions, the banks cannot deny the invocation of the guarantee. Now we have discussed on the separability of contract, but once again, I just want to highlight how these two things differ to each other. There is the principal to the vendor, there is a contract for execution of the particular work. Out of this contract, suppose there is a condition that the personal security is to be used. This is emanated from the original contract. But the party is not the privity to the contract. On the insistence of the party, the bank is to give the guarantee in favor of the principal. So here, this is coming under the purview of section 126 of the contract law. There are three parties. One is the principal debtor, the other one is the creditor, the third one is the surety. The guarantee is normally given by the surety to the principal debtor, that is the principal, on behalf of the to the creditor on behalf of the debtor. So there are two parts. The bank guarantee or letter of credit is an independent and separate contract and is absolute in nature. The existence of any dispute between the parties to the contract is not a ground for issuing an order of injunction to explain enforcement of bank guarantee or letter of credit. So this is very clearly decided by the Supreme Court in the Katinap judgment. So therefore, under the guise of these exceptions, no bank can deny invocation of the bank guarantee. This is a case relating to the bank guarantee and the law decided by the Supreme Court in this case, Corporation. So wherein the bank giving such a guarantee is bound to honor it as per the law, irrespective of any dispute. The final point is irrespective of any dispute raised by the customer. The very purpose of giving such a bank guarantee is otherwise be defeated. The court should therefore law in granting an injection to restrain the realization of such a diagram. Although,
Mr. Jaina, again, please.
yes, ma'am.
The sound is low.
Sound.
Yeah.
Okay, ma'am. Okay. Yes. So I think I have to be closer. Yes, ma'am. Now I am audible. Hello, Kavita, ma'am.
Yes, sir. It's better now.
Yes, ma'am. Yes. The courts therefore show in granting an injection to restrain the realization of such identity. Although practically the enforcement of an unconditional security instrument will depend on an event of default under the underlying contract, the question as to occurrence of a default usually, unless a contrary indication appears in an instrument, left to the subjective unilateral decision of the guarantee. Had the opposition been to the contrary, that is, the default had to be established under the main contract in arbitral or civil proceedings, the object of ensuring timely cash flow to substitute the creating generation. So broadly, what the Supreme Court said, it is the rarest of the rare case the guarantee can be denied. Otherwise, the bank are deeply bound to give entire the bank guarantee. Then comes a contract document. Once the tender is finalized and the customer or letter of acceptance, and in line with the tender, there is a contract document, part of the tender document. But broadly, what are the issues to be seen that we are discussing? When the tender of a contractor is accepted, an agreement between the contractor and the owner takes place, and the document is defining the rights and obligations attached to the agreement, and this is called the contract document. Each page of the contract document bears the signature of the contractor and the accepting applicant is correction in the details. Why this is being done? Because there may be some conditions, some additions, affirmations, and therefore, in each and every case, signature of the parties are required. If so many issues arose in the process when we came to the dispute, and sometimes the party stated that I am not agreeing to that, I am not agreeing to that one. That is why invariably in each page of the document, both signatories should be there. Here another one thing is to be kept in mind, whether the person who is signing it on behalf of the party A or party B should be competent to sign. Because you read in section 10 of the contract law, it should be valid contract like competency, like offer, acceptance, lawful object, and consideration. These are broadly the details of the contract document. So, like title, that means the preamble part 1, part 2, the name, detail of the owner, and the details of the contract, phone number, email ID, address, everything is to be mentioned in the first part, that is known as the preamble of the contract. The next one is the index page, that is in the first page from this to this, page number 1 to 10 contains the technical specification. Page number 11 to this relates to the pricing mechanism. So likewise, it has to be mentioned in the second stage. Then the tender notice is basically an integral part of the contract. Please keep in mind, whenever going for a contract, this should be invariably mentioned that the tender notice is forming the integral part of the contract and agreement. And then other aspects like scheduling of the material, drawing, specifications, general specifications, detail specifications, technical specifications, all these things will be mentioned in there. Then conditions Normally, the conditions means when the payment is to be made, what are the, who is the signing authority, who is the verifying authority. If there is any, if there is the sequence is not maintained at the time of releasing the payment, there may be so many issues arose. Therefore, it has to be invariably mentioned in clear terms what is the role and responsibility of the members of each stage. Why I am saying so? Because in mega projects, a lot of people are involved in the process. Suppose the site engineer signature is required before completion, and once it is completed, then he has to raise the invoice. So that invoice is going to the finance department. So the finance department only sees whether the certification is made by the designated person or not. So he will have to go to the part is mentioned in the contract itself that one. What the hello?
I think some connection issue.
No, I mean this.
Yeah. Okay. Fine.
There is no issue at all.
Okay, because your sound is becoming very low again, and
There is no issue at all, ma'am. It is okay.
okay.
I think there is some other technical issue because I attend to. Voice is okay, ma'am.
Yes, sir. When you start speaking, it's fine, but slowly it goes down. And most of the participants are repetitively saying that they are not able to get you. Yeah, it's better. Yeah.
I'm very loudly I'm saying, ma'am, because it's only generating the virtual process.
Okay.
Because I'm trying my best.
Okay. Okay.
Okay. Yes, ma'am. So this risk factor and has to be passed on once the work is completed and in each stage of completion of the work. So that has to be mentioned invariably. Otherwise, any defect or any quality issue or any other issues arose out of that factor, then the next person will be responsible unless and until it is mentioned in the contract. Defect line then the penalty provision, whether for unsatisfactory work progress, poor quality, what is the penalty, and it has to be very, very categorical in nature. It should not be subjective. It should be very clearly mentioned. Then termination of the contract. So whether by giving 1 month notice and what is the ground has to be mentioned by either party. It should not be using at will. Then arbitration settlement of dispute clause. So because each work order or each sale purchase order has always some dispute, always very complicated by either party. Therefore, the arbitration or settlement of the dispute normally nowadays before the arbitration there is a conciliation process. So that is known as mediation arbitration clause. It is normally concept developed by the European countries and America. Now we are following this for the last 8 to 10 years in India. So in the first stage you have to go for a conciliation, and if a conciliation fails, then you have to go for arbitration. So directly one cannot avail the. There is a message, ma'am. There is a voice is low. Now, ma'am, I am audible. Now, okay.
Yes, sir. When you start speaking, it's audible, but slowly it goes down. And then, we are not able to hear you. I'm sorry to repetitively interrupt you.
हेलो, इसमें ये थोड़ा साउंड बढ़ गया, डाउन हो गया. हेलो,
बड़ा है अभी.
बड़ा?
हाँ.
हेलो, हेलो.
हाँ जी. Yes, sir, we are getting you.
Sound increased or decreased?
It is increased.
Increased?
Yes.
But your voice is not audible to me, ma'am.
Hello, am I clear now?
Yes. Hello.
Yes.
So I am clear to you now, ma'am.
Yes.
Okay. The arbitration for settlement of dispute is an integral part of a contracting system. So therefore, it has to be invariably mentioned. There are two key ingredients, like arbitration by the other committee or by an institution. That is first part. Second part is substantive law. Third part is the jurisdiction. So very recently, in one case, prediction in Supreme Court 2019 December, November, the sole arbitration appointed by the authority, that means director, chairman, general manager of a company, has been negated by the Supreme Court. So that is not permissible at this juncture. That's what I mean to say. Earlier days, in each and every contract, it has to be mentioned the CLD of the company is authorized to appoint the arbitrator, and it is binding on the other side. In the particular case, prediction case, it went to the Supreme Court in 2019 November. Supreme Court said this arbitration clause is bad in law, and it has unilaterally decided the appointment of the arbitrator. Therefore, this arbitration clause is not permissible. So my point here is, you are supposed to go for an arbitration clause which is valid and not in clash with the Supreme Court decisions. Hello. Next. Special conditions. Depending upon the nature of work, taxes and reality included in the rate, labor camp, labor amnesty, compensation. All these things to be taken into care by the special conditions of the contract. Conditions are come to the contract. Now we will come to whether a LOI, letter of acceptance, letter of intent, purchase order is conditional or it is unconditional. If it is unconditional, then there is no issue. If it is unconditional, if it is conditional, then unless and until the condition is not completed, then it is not a valid contract. So when the essential condition, one who there is coming yes. Now it is audible. Yeah, ma'am.
Mr. Jaina, your video is off.
Whether a condition is for completion unfulfillment of just rejection of the tender, then it would be ethical part of the tender. The case of Kanyana, hello, ma'am.
Yes, sir.
Hello.
Yes, Mr. Jaina.
Hello.
Hello. Yeah.
Hello. Ma'am.
Hello.
Hello.
Yes, your sound is coming.
Hello. Hello.
Yes, yes.
Audible? Hello.
Yes, Mr. Jaina, audible.
Kavita ma'am, I'm audible.
Yes, yes. You're getting me? You're able to hear me?
Hello.
Yes, Mr. Jaina, you're audible. Hello?
Hello.
Yes, Mr. Jaina. Yeah, please continue. Yes,
I'm
yes.
audible. There is some problem.
Yeah. Mr. Jaina, you kindly let me know when we can go for a question and answer session. I have received a lot of questions.
Yes, ma'am. Yes. We'll come. Another 10-15 minutes. I'm completing. Then we'll come.
Okay.
Yes, ma'am. This is Air India versus Cochin International, where the apex court held that involving award of contract made it clear that the public authority is free not to accept the highest or the lowest offer, and the scope of judicial review is confined. Now we are coming to the court intervention in the tendering process. It can annual the same is found to be vitiated by malafide, arbitrariness, or total unreasonableness. The broadly court view is if the tendering process is vitiated by malafide, arbitrariness, or unreasonableness, then in that situation court will interfere, otherwise not. Likewise, there are 3-4 judgments wherein the same view has been taken by the Honorable Court. Judicial review of administrative action is intended to prevent arbitrariness, irrationality, unreasonableness, bias, and malafide. Its purpose is to check whether choice or a decision is made lawfully and not to check whether choice or a decision is sound. So this is here whether it is lawful or not. So the court is not required to check whether the decision is sound or not. When the power of judicial review is invoked in matters relating to tenders or award of a contract, certain special features should be borne in mind. The contract is a commercial transaction. That is why the court interruption is very, very minimized. This is a landmark case in the tendering process. Today, this is also valid law and it is settled. So I will go in detail of this. This is Michigan Rubber versus State of Karnataka 2012 Supreme Court. The court interference is not warranted in the matters of tenders and awarding of contracts unless the action of the tendering authority is nullified and there is a misuse of statutory power. This is a broad guideline. The next one is scope of the court interference is very restricted and limited, and courts cannot interfere in tender matters and awarding of contracts where state act reasonably, fairly, and in public interest. No person is guaranteed with any fundamental right as per the Constitution of India to do any business with the state or its organization. To decide NIT, tender conditions, eligibility, RFP conditions, eligibility criteria for tenders, the government and its institutions have free hand. The scope of judicial review arises only if above said items are done on arbitrary, discriminatory, malafide, and activated basis. The courts cannot interfere in a tender process on the basis that some other terms in the tender would have been fairer, wiser, and more logical. Judicial review cannot be denied in contractual matters or matters in which the government exercises its contractual power. Such review is intended to prevent arbitrariness. The next one is, this is evaluating tenders and awarding contracts are essentially commercial functions. Principles of equity and natural justice stay away at a distance. If the decision relating to award of contract is bona fide and is in public domain, court will not, in exercise the power of judicial review, interfere even with a procedural aberration or error in assessment of the tender is made out. The power of judicial review will not be permitted to invoke to protect private interests at the cost of public interest or to decide contractual disputes. The tenderer or contractor with a grievance can always seek damages in the civil court. Attempts by unsuccessful tenderers with imaginary grievances, wounded pride and business rivalry to make mountains out of molehills. Some technical or procedural violation of some privileges and pursued court to interfere by exercising power of judicial review. Such interference, either interim or final, may hold up public works for years or delay release and spectacular thousands and millions of people. So broadly, what court is saying, in rarest of the rare cases, the court can utilize the judicial power of the review and restrain the public authority or the organization to proceed. They are not the court of appeal and they cannot review the decision taken by the authority. Only thing, if there is an arbitrariness and unreasonableness, then only it has to be taken into consideration. Otherwise, the court will not interfere in the process. So this is what exactly the same thing. So we will quickly move. This is the arbitration. This is a very recent development. This is a contrary view. In PSA Mumbai investment versus Jawaharlal Nehru Port Trust, there was a consortium, and in the first phase there was no dispute. In the second phase there was a dispute, but before that arbitration clause is signed, the dispute arose. So ultimately, the Bombay High Court said this is the arbitrable dispute. But when it comes to the Supreme Court has decided that it is not, the arbitration clause is not valid and it is not arbitrable. So now we come to this, I will come to the little bit of the fact of this case. It was held that the disclaimer of the RFF makes it clear that there is only a bid process that is going on within the party and there is no concluded contract between them. That is section 7, what I have elaborated in initial stage. That such bid process would subsume letter of acceptance to be issued by the respondent in two further steps under the city to be gone into before the draft final agreement. That means here the letter of acceptance was not issued and there was some Jawaharlal Port Trust has cancelled the process. So ultimately the matter is Bombay High Court. Bombay High Court said it is arbitrary. Ultimately Supreme Court said it is not arbitrable. And final conclusion is there was no absolute and unqualified acceptance by the two or three very important steps have to be undergone before there could be said to be an agreement, which would be enforceable in law as a contract between the parties, and hence arbitration cannot be involved in the civil case. This is prior to concluding the process. There is a contrary view, just a reverse view. Karnataka Electronic Corporation case, there are again subcontractors are available. Here the case is the subcontractors have no privity of contract with the Karnataka State Electricity Corporation, Electronic Corporation. Here the court said, while analyzing case of chloro controls versus seven pent water purification, it has been said that the parties can be made amenable to arbitration arbitration could be possible between the signatory to an arbitration agreement and the third party. Here the final point is, even if the third party is not a signatory to the original arbitration agreement, but he is connected to the first agreement, then he can also invoke the arbitration. So this is clearly contrary view, though it is not very similar. Here is the case, it is a concluded contract. Here it is not a concluded contract. So now this is the last one, the letter of intent. So from the terms of the letter of intent, normally before you go for a detailed contract, the principal is to issue letter of intent, letter of acceptance, sometimes put together. So as per the law, LOI is not a concluded contract, but sometimes the long-term contract or a concluded contract is not issued, and based on the LOI, the work is doing there. And dispute arose, then what will be the how it is to be resolved. So in one case, Bindal Agro versus State of Bindal Agro versus Professor Rand, it has been decided that if will certain law that merely indicate the party's intention to enter into a contract with the other party in future. A letter of intent is not intended to bind either party ultimately to enter into a contract. But the terms of the LOI will decide whether it is a concluded contract or not. Sometimes in my company there is a LOI and it is finally decided that it is a contract with some public sector undertaking. So it depends upon how the language is used, what is the intention of the party, whether it is a condition or it is a formality. So with this, I will conclude my deliberations on this issue. So we can switch over to the questionnaire session. Okay, Kavita ji?
Sure, sir.
Okay, so I am concluding this one. So,
okay.
Any queries or questions you can will ask.
Sure, sir. Thank you very much. And there are a couple of questions which I have received, and I would request you to be more louder when you respond to them. So the first question is.
Am
I audible? Am I audible?
Hello. Yes,
okay. So the first question is whether RFI, RPI and RFQ can be enforceable in the court of law and whether they can be used as evidence.
Can be used in the law subject to acceptance. Suppose the intention of the party and it is not binding. But my answer is, if RFI, RFQ or RFP, there is a condition that it is binding on the party, then it is enforceable.
Okay.
If the intention of the party is that it is non-binding in nature,
okay,
then it is not enforceable, it has no significance. And even if it were used as evidence, it has no.
Okay. So you are saying when these documents contain a term called binding, then it will be enforceable in the law. Otherwise, it's kind of a non-binding MOU sort of.
Yes, ma'am.
Okay. So the next question is, what are the parameters that are evaluated by TOC and TEC respectively?
The tender committee and tender evaluation committee.
Yes.
It depends on case-to-case basis. Normally, tender committee role is to examine the technical and financial due. So whereas evaluation committee role is more technical in that direction. Because it depends upon what is the tender notice and what is the work which is undertaken. Evaluation committee is in a better place and better technically sound to go in detail evaluating the issue and give a conclusion. Whereas the tender committee, the initial first stage, they are only based on the document what is available, whether right or wrong, yes or no.
Okay. Thank you, sir.
Yes, thank you.
The next question is, are submissions made in the RFP legally binding like an agreement on the party making submissions? Further, is it possible to amend the submissions made in the RFP while entering into a formal contract?
One second, ma'am.
So, sir, there are two stages. Once you submit the RFP, so the participant has asked whether RFP will be a legally binding an agreement on the party which is making RFP. This is one. And second, once you have made the RFP, whether it is possible that the contents which you have made in the RFP can be amended while signing the formal contract.
Yes. So first, very answering. When you are submitting the RFP, it is in nature of an offer. Once the offer is given and if it is accepted, if it is unconditional, there are two things. The offer is unconditional and accepted, then it will be binding in nature.
Okay.
And the other party, the second party is whether the activity can be modified. Normally, it is not permissible once you have given. But subject to the issue that if the principal is accepting a modification, that means it will be again a cross offer or a re-offer.
Okay.
Suppose you have given one RFP and you wanted to modify the terms and conditions. So that is, and with the permission of the principal. Then, and if you are revising and it is subject to approval by the other party or acceptance by the other party, then there is no issue at all.
Okay.
But it is not isolation. It is not authority of the vendor to modify. So once the time is over.
Okay. Sir, but how far the legal terms in any kind of a government bid can be negotiated or changed? Are they amendable as per the negotiation, or once it is written by the government and it is like
No. It is
a final order?
It is negotiable. It is negotiable.
No, I'm talking in terms of legal clauses like arbitration, like penalty, like jurisdictions. So whether these clauses can be negotiated and amended. I think we have lost the connection. Mr. Jaina?
We have lost the connection.
Yeah. Tanisha, can you please connect with him?
Okay, ma'am.
Participants, kindly wait for a few minutes. I think there is some technical issue. Yes, sir.
Yes. Hello.
Yeah.
Are you?
Yes. So the question was whether the legal clauses like arbitration, jurisdiction, penalty, these kind of clauses can be negotiated and amended in the government bids.
One second, madam, I cannot hear it clearly. One second, please.
Once again, you want, okay. So the question was, in the government bids, whether the legal clauses such as, jurisdiction, arbitration, penalty, assignment, whether these clauses are negotiated and, can be amended.
No. Because
Yeah.
these clauses, again, it is a arbitrariness to other states. So, started negotiating with the other participants. That is not negotiable. I am audible, na? It is not
Yes.
negotiable.
Okay. So the next question is, how far can we go, that is L1, L2, L3, before re-tendering?
I cannot follow correctly.
I repeat,
Yes.
how far one can go to L1, L2, L3 before re-tendering?
There is no standard law or formula for this L1, L2 or L3. It depends upon the particular work time schedule and expertise of the particular person. It has to be decided on case-to-case basis. There is no straight jacket formula or law.
Okay.
Yes,
Sir, many of the participants have asked whether the PPT can be provided to them or whether it can be circulated.
Actually, it is not for private circulation. So, if any individual is interested, they can give his number. I can. Otherwise, it is not for public. I can.
Okay.
So, my request is not to circulate also because I have shared with you in the petition.
Sure.
Yes.
Okay. So the next question is, in tender opening committee, who will be the member?
It depends upon the organization whether they want. Normally, there should be a person from marketing or trading side. There should be a person from the finance side, or there should be a person from law or audit side. Audit. So normally there are 3-4 members there. But it depends upon the organization itself whether they want the particular person or not. It depends upon there is no straight jacket formula. This person should be there. But
No, probably the question with the perspective is whether there is a rule behind it that one person from this ministry, the other one from this secretariat, should constitute. Okay.
No. It is in-house.
Okay. So could you please explain once again what is web publicity?
Web publicity.
Yeah.
Actually, I don't have knowledge on this area like term internally. But web publicity in general is the website is publicity. In general, you have to provide publicity in your website.
Okay.
It is accessible to all the people because there is no restriction, password, registration, all this is not there. It should be in a common platform in the company's website. Everybody should have access to that website without following the restrictions.
Okay. Thank you, sir. The next one is, in case of delay in refund of EMD, what would be the rate of interest?
Standard rate of interest, bank rate of interest is very clear. Suppose right now it is 10.57%. So that much is initiated, not beyond that. Bank rate, that means the particular bank is giving based on the proceeds which are applicable.
Okay. So, sir, whether this rate is defined in the bid itself?
No.
Okay.
No. There is an act is there, but that is under the jurisdiction of the decision of the court. Normally, earlier days it was 10%. Earlier days.
And in reality, whether the interest is paid in case of delay?
Yes. Because if there is abnormal delay, it has to be paid. But the normal principle is why the question is normally when the input is not payable on evening.
Yeah.
Already your question now. But if it is abnormal delay, it is suppose 6 months, 1 year is for 1 2 months you can say. But if it is 2 months, 5 months, 6, 7 months, in banking you cannot say. Critical question. Normally interest is not payable on the EMD, but if there is abnormal delay, then it is fine now.
Okay. So the next question is, the letter of intent having all terms and conditions is not a contract. Purchase order is also not a valid contract, as in many transactions we go ahead without agreement basis of PO. Would like to know enforceability in the court of law such letter of intent or PO.
No, the letter of intent can be a contract. Purchase order or letter of intent can be a considered contract. If the language used in that LOI signifies that unequivocally all both parties are agreed to these terms and conditions. Suppose there is a term used in the LOI or in the purchase order stating that a long-term contract is being signed within this particular time frame, or there is some other condition stated therein. In that situation, it is not a contract.
Okay.
It depends upon the language, intention of the party, and what they wanted to do. Whether they wanted LOI considered contract by itself, or they wanted full-fledged contract to be signed in due course.
And sir, what is the sanctity of PO?
Purchase order is also a contract because so many court decisions are there.
Correct.
Vedanta aluminum case is there, so many. Finally, Supreme Court held if there is no full-fledged contract and what is going based on the purchase order or the LOI or the letter of intent, and the parties are conducted acted upon means, I think you are following me correctly.
Correct.
They have supplied the material, received the payment, and then it is a complete contract by itself.
Correct. So if the PO has been issued and accordingly the supplies have been made, it's a kind of a binding contract under the Contract Act.
Yes.
Correct. So here I think what the participant is trying to understand that there is a process, right? So there is a LOI, then there is a PO, and then finally there is a formal agreement. Yes. So if there is a formal agreement, what is the sanctity of LOI and PO? Whether they still govern or no, the final terms of the formal contract is govern.
Necessarily that you have to follow the process. Normally mega project, the price is increasing normally. Suppose you have a power plant construction to be made 10,000 crores, and you have to start work immediately. So once the tendering process is over and the party is certificated, immediately you have to issue the LOI, pending finalization of the long-term contract. So that situation it is a sanctity. In that situation it is not a contract by itself. Sometimes what is happening, the LOI is the long-term contract or fulfillment not signed due to obvious reasons. And the work is going on based on the LOI or the purchase order. That became a contract by itself. So the final point what you are asking is whether what is the there is no necessity sometimes. You have the tendering, finally you can directly go for contract or agreement. But it depends upon the nature of the work you are practicing, the hindrances, because in the administrative process time is taken for signing an agreement. So that is
Okay.
immediately a LOI is issued. Yes, ma'am.
Okay. So the next question is, will there be any deduction while returning the EMD money?
When there will be
Any deduction
on what account?
for any account? So earnest money deposit,
No.
it is any adjustment
Either investment will be forfeited or earnest money is refunded. There is no percent deduction.
Okay, no adjustment is possible.
Yes.
Okay. In many tenders, security deposits and performance guarantee both are taken. Is there any specific reason behind it?
In fact, at this stage, before issuing the performance guarantee, security deposit are taken. Before giving performance guarantee, deposit are taken. But it depends upon the organization and the setup. You can take both. But in the present context and as per the present law, performance guarantee is a better mode of security than the security.
Okay. So the one of the
one final point, because the performance guarantee limit defect liability period is around 6 months to 1 year. Whereas in a security deposit, once the company is there, you have to immediately refund it. You cannot return it for defect when the defect is rectified.
Okay. One of the participants wants to know that can you please give the example of irreversible injustice? Irreversible injustice.
Suppose in wrongful way. It depends upon wrongful. I will give an example. Suppose I am purchasing coal from international market and selling it to an Indian party. Okay. And the Indian party has gave a bank to me to charge the liability. Okay. So this is party. There is a case also related to that suppose the power plant is the person who is taking the coal due to the government law or government notification regulation, his power plant has been closed down, for example. So he is not in a position to take coal from him, though he is having an agreement with me. So in that case, when I am invoking the guarantee, it may lead to injustice, so which can be decided by the arbitration or the civil case. So this is not the right forum to invoke the guarantee, and this is the right place for justice is not met out. Because government regulations have prohibited him. He is not intended or he is not have malafide intention to perform.
Okay. Sir, somebody wants to say whether you have referred some CVC guidelines for award of tender.
Yes.
Okay. So is the bank guarantee?
There are three basically technical aid, financial aid, CSR. I have said 3-4 slides with CVC guidelines. It is there.
Okay. And the second part of this question was, since the bank guarantee is unconditional, what is the significance of two different dates, that is validity date and claim date?
Normally validity date is suppose 31st October, claim date is normally 1 month beyond or that date. Because till such time, suppose you have any issues relating to the contract, you have a cushion in your hand, nothing else. It is like you should have a cushion in your hand, but there is, if any issues arose relating to the contract, I should have a time involved.
Correct.
Nothing else.
Yeah. Can unconditional bank guarantee to be issued have assignment clause? Generally, banks have objection on having open assignment clause in bank guarantee.
Normally, there is a restriction on the issue by the RBI. Insofar as bank guarantee assignment is concerned, I have never heard about it. But as far as my knowledge is concerned, it is not assignable. Hello?
Yeah.
Because bank guarantee is directly to the beneficiary. So suppose the beneficiary is giving an option that in case of a defect, then party B to be in a position to invoke the bank guarantee. In that situation, the bank guarantee has to be modified. Now you are listening to me, no? So what I am intending to say, suppose bank A has issued a guarantee to bank B, to the business owner B, and B wants its assignment to be made to C. Then in this case, C can invoke the guarantee, but without the consent of A, C cannot invoke. That means the bank guarantee is required to be modified to that extent. The law of assignment is very clear, man. Under the bank guarantee, law of assignment is if both the parties wanted, then the assignment can be made.
Okay.
Partially or fully.
Okay.
To perform some part or the whole part.
Okay.
But without a single party, you cannot assign it. Suppose in this case, bank A issued the guarantee in favor of the beneficiary, that is B. B wants that instead of me taking the benefit in case of an exigency, it may be passed on to C. He wants. What I understood from the question. So in that situation, without the consent of A, that is bank, he cannot
Assign it. Okay. So the next question is, if the bidder files a conditional bid and the authority accepts such conditional bid, will the conditions become binding upon the authority and therefore shall have to be incorporated into the contractual documents?
Actually, conditional bid became invalid. The general law is conditional bid is invalid. General law. But what your question is, if it is accepted by the authority, that means he has modified the condition has been weak. In that situation, without consent of the vendor, you cannot impose upon him. So what is your question? Once the authority has accepted it, can it be imposed upon the vendor? Is it possible? Hello?
Yeah.
So suppose the vendor has given a condition, whatever the condition has been waived by party authority, but without the consent of the vendor. If there is a consent of the vendor and I am agreeing to the waiver clause of the authority, then it becomes operational. Otherwise, it is not operational.
Okay. So the next question is LOI or LOA binding on issuing party. Whether they are binding on issuing party.
Yes, because the bindingness is not on issuing party or the other party. Binding is between the two parties. The section 7 of the contract law says it is unconditionally accepted. Section 7 of the contract law says the offer and acceptance binding and unconditionally, unqualifiedly accepted. So it is binding by both the parties, matlab party A and party B. It is not the case of binding on party A and not binding on party B. It is not like that. And there is a principle of consensus ad idem. Principle of consensus ad idem is so exactly what you have intended, the same thing has been accepted. If there is any variation in the acceptance, that is again a cross offer. So LOI, suppose I am giving an example. Suppose I have asked for a pen, a red color pen. This is a simple example. But you have given 9 red color pen and 1 blue color pen. Because that is not available at your end. Fine. So in that situation, it is not unconditional acceptance. Ma'am, I think you are it is a very simple example, but whatever is given by the offering has to be accepted in photo. That is another principle is mirror image theory. Mirror image theory is what you have seen in your mirror. Exactly what you are. So there is a variation at all. Likewise, in LOI or letter of acceptance, whatever offer is made, the same has been accepted in the same mode and stipulated time frame. Otherwise, it is not accepted. Considered. Hello? Hello? I'm not audible. Hello? 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 Hello?
Sir, am I audible?
Yes.
Hello?
Hello?
Am I audible?
Audible.
So, sir, effectively, you were saying that LOI or LOA, once they are accepted by the other party, they become binding on the issuing party as well. That's what you are saying.
Yes, but there should not be any condition. The final point is, if the LOI again is conditional, again it is not a complete contract.
Okay.
Unless and until the LOI condition is fulfilled.
So can it be said that
Hello? Hello?
another question?
Hello? Yes, you the voice break. Hello?
So can it be said the LOI and MOU are similar in nature?
Yes, there is minor variations, but it is similar in nature. MOU is in a lesser footing, LOI is in a better footing.
Okay.
MOU, there is broadly is a understanding, but it is non-binding nature in general. In general, MOU is the understanding, broad understanding, but non-binding. But if the intention of the parties is that MOU shall be binding in nature, then it is a computer contract. There are 2 judgments of Supreme Court. Yes, ma'am. Hello? 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 Again, voice break.
Yeah. So, sir, the last question is whether bid security can be adjusted against performance security.
This is exactly issue in one of my companies. We have adjusted, but there is no general principle. It can be, but there is no general principle. In my company, we have adjusted.
Okay. Sir, one last question has popped up. Any suggested timeline for keeping the tender open at its various stages, modification of terms, etc.? So any timeline has been given by the...
It depends upon the item, whether you are running short of time, the prices are going up. Normally 15 days to 1 month, but it depends upon the case. Normally 1 month.
Okay. So, sir, I think this was the last question, and the time is also coming to an end.
Yes, ma'am.
So, thank you very much for your precious time. And though there was some technical hitch, but I presume the participants must have been benefited from your knowledge and sharing the content. So, a sincere thanks from all of us on behalf of ICSI. And I would like to present the certificate named Shaheed Ki Beti. Tanisha, can I be given this access?
Yes, ma'am.
You have access, ma'am.
Yeah.
Yes, ma'am.
So, sir, this is the certificate, which is a token of thanks from and on behalf of ICSI. So kindly accept it, and the hard copy of the same will be shared with you shortly.
Yes. Thank you. Thank you. Giving me an opportunity and giving me acknowledgement. Thank you. Madam के नाम
So thank you very much. Yes, I'm not able to hear you. Yeah.
Thanks a lot, man. Thanks to Kavita ma'am. Thanks to Manish ji. Thanks to Tanisha. Thanks to Institution of Company Secretary of India to giving me an opportunity to share my views. Thanks a lot.
And participants, we have noted certain concerns you have raised. ICSI will be responding back. And if you have any questions for Mr. Jaina, we will be sharing his email ID with you, so you may kindly get answers directly from them. So thank you so much, and have a good day.
Yes. So thanks to the participants once again. Thanks a lot.
Okay, thank you.